fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything look smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome to the show. I am your host, Daniel, and our judge today is Judge Jeffery Middleton. Like I said, we're losing him because he's retiring at the end of this year, which is really sad. I like him. He's a good judge. Let's get started with Judge Middleton's docket. Yes, I'll be here watching, but I will be muted. I'll be watching for ads so I can skip ads. So I am here watching. Make this bigger. And I'm going to mute.
To give in this matter will be true to the best of your knowledge and belief.
Yes, sir.
All right, Jessa Marchand has filed a lawsuit asking for $1,845.92 as a residential lease. She says improper refund of deposit from landlord, damages to items while living in a moldy house. Ms. Butler has filed a counter complaint. The lawyer helped you with this, which is why I can't make any sense of it. Cost to replace the carpet is $1,000. The cost to replace the refrigerator is $738.82. So your counter suing for $1,738.82 for damages caused by the defendant or the plaintiff and her boyfriend. All right, Ms. Marchand, let's start with you. You're claiming $1,845.92. You contend improper refund of your deposit.
Yes,
and
so for the deposit, I just received a personal check in the mail. No reasoning for why I should have not been refunded all of my money. And I just felt like that was improper.
Well, she explains why it is. When you left, did you go through the inventory checklist with the Butlers?
No.
When you left, did you give your forwarding address in writing within
Yeah.
4 days of your moving?
Yes.
All right, all right, I'll come to you. So you're saying under oath you did give her your forwarding address?
I sent it to her over text.
Let me show you something that makes me furious every time I see it. This is a real tax.
And then I waited and I thought that it would be sent within time. So I thought that I was going to receive the check. And then I checked the mail for like a week and a half, and I did not receive it. So I sent her another message and she said, sorry, I forgot.
She is supposed to give you a letter. One thing triggers another. So when you move out and you turn in your inventory checklist and you give your forwarding address in writing, it triggers their response as a landlord to either return your deposit or return the deposit minus rent or other damages, and they have to give you a security deposit notice. Did you ever get any letter from her regarding why she was keeping your deposit?
No, this is all I received was this envelope with this personal check. And it is not even with a return address.
All right, how much was the deposit?
The deposit was $950 and I got a check back for $250.
With no explanation.
Absolutely none.
We talked on the phone.
I'll give you a chance to speak.
Okay.
This is her time. You're a landlord. You're required to understand the landlord-tenant rules. In fact, under some circumstances, you could be liable for treble damages, 3 times the amount of her deposit. There's a case called Havanesium versus Lamb that says the landlord is supposed to understand the rules and they're strictly to adhere to them. So far, you haven't adhered to the security deposit law. So you can't just send her a check for $250 and not tell her why you're keeping the rest of it. So we got problems right off the bat. All right, Miss Marchand, then you're also, I got pictures of a moldy coat and a skateboard and some other stuff. And then
My child's car seat carrier as well.
all right, so, and you list a price for each one of those.
I sure did.
All right, so tell me about each of, what's the rest of your claim, 1845?
Oh, sorry, what was that?
Well, what's the rest of the damages that you're suing for?
Just the items that were damaged, the prices on there, and then the
All right.
$950 for the deposit.
All right, well, let's go through that. I've read it. I saw your pleadings, but you're under oath, and this is where you give your testimony.
Yeah.
All right, so
Absolutely.
what were the items?
The items were a longboard, which considered to be a skateboard, a riding jacket with
All right,
padding in it.
slow down. How much, and I've got this in here. How much was the longboard?
Sort through here. Longboard retail is $136.99.
All right, and what else?
The riding jacket is a motorcycle jacket that is padded for riding a motorcycle on the road. And that retails at $119.95.
All right, go ahead.
Next, I have the motorcycle helmet, which retails at $79.
All right,
Next, I have our air conditioner unit that filtered out all of our air in our bedroom that we breathed in, which was $329.99.
and the car seat?
And the car seat was $229.99.
Now, you've given me retail price for brand new stuff and everything is used. But
Correct.
Let's add that up. 136.99 plus 119.95, 229.99. plus 79 plus 329.99. That equals 895.51.
I might have done my math wrong. Oops.
Well, or I might have. We'll check it again. All right, where were these things stored?
So obviously the air conditioner was in our bedroom. The child's car seat was actually in my child's bedroom next to her crib, and I pulled it out to use it, and I discovered that it was covered in mold. So we were living with that in our living space where we were sleeping. Everything was just kept in the house. Everything was in the house that got moldy.
I assume those are the only things that got moldy?
Yeah, I mean, that's the only thing I have record of, unfortunately. Other things we just started tossing and they weren't salvageable. Or if there was
Well,
things that were
for
salvageable.
example, the helmet, it would seem like you could just clean it.
The interior where you breathe in was also covered in mold.
So the property was in the living quarters of the unit.
Yes.
And they had mold.
Yes.
All right. Now,
So may I add that she did also have companies come out and try to remediate this mold, and they also just caused us more issues of living in the house. She had a company that came in and they used spray paint and sprayed all the cabinets and left all of our belongings in the house with the spray paint. And we came home to our animals in this house that was not even ventilated at all with spray paint. So we went through that as well. And then she had another company come out and clean all the spray paint off of our stuff, which was another headache in itself.
how long did you live there?
Planning to move? Choose Pods, the most.
I think a month over a year. So we moved in September, we moved out in January. So September to January over the lease.
So you're saying when you were absent, they had someone come in and spray paint your kitchen?
Yeah, she asked us to leave the house unlocked and let them come in and do it while we weren't there.
With your animals in the house?
Yes.
And it got paint all over your personal property?
Like they did, so the mold started in the kitchen and that's where they were trying to tackle it. So they had us remove everything from the cabinets. We thought that they were gonna paint with a brush, but they used a spray paint and they didn't like mask off anything. They didn't cover any of our belongings. They just went at it with the spray paint.
All right, and then what was the other thing you mentioned?
The company that came in to try to clean up the spray paint.
So she didn't ignore, you said, hey, I've got mold, and then she did try to do some things to fix it.
Yes, but I don't think that they were the proper steps.
All right. Is there anything else you want me to know?
I think I've said everything.
All right, well, we'll come back to you. All right, Miss Butler has counterclaimed for carpet and refrigerator. Miss Butler, first, what do you have to say in response to Miss Marchand's claims regarding the security deposit and this mold damage?
First, they did not move out until February 5th, I believe. That's 3 weeks into the next month. They were only paid through January 19th. So that's the difference. And it says in the lease, I can take, unpaid rent
You
out of the
can.
deposit.
But you have to do it right. So, all right, so you had
You should know the house was completely redone before they moved in. The entire house was painted, ceilings, walls, everything was painted. I had new laminate floors put in and new carpet in the 2 bedrooms and the living room. The bathroom was completely redone with a new tub and shower. I think that was everything that was done
All right, well,
to the tune of almost $20,000.
well, and I'm familiar with this house. We've had a previous claim regarding this house.
No,
Was this Isabel's house?
this is Isabel's house.
All right.
The other one was on North Fisher Lake.
All right. Well, I'm familiar with this house for a different reason.
I know.
But we'll just leave that aside. All right. So the house had been redone, but obviously there was a mold issue. She shows this
Not
property.
until they moved in.
There was mold when we moved in.
All right, well, stop. Same thing for you, Ms. Marsh, and only one person can speak at a time. So this is her turn.
My point is everything was fresh and clean, new paint, new carpet, new floors, new bathroom when they moved in.
All right, and that's fair enough, but if no one's living in there, when you start living in there, it's warm on the inside, it's cold on the outside, people are in there. You don't bring mold in like you bring bed bugs or cockroaches.
No.
Mold is an inherent issue with the dwelling.
They
Yeah.
had a building across the road. It's an old garage. And I believe some of those things were stored in there. And that property basically had been abandoned for about 8-10 years. There's a garage there. And I believe they had some items, like the skateboard and helmet and
All
that
right, so
sort of
you
thing
don't
stored
believe-
there.
When they moved out, did you find mold? Because it would think if
No.
that child seat is in the bedroom, that everything in the bedroom would be moldy, the bedding, the carpeting, the
And I have
drapes.
proof that that was not true. The child's seat, when I talked to Jessa, the day she finally moved out, was in perfect condition. It was sitting there in the family room.
Say that again.
The car seat, the child's car seat, was in perfect condition when I saw it the day she moved out. I wouldn't put a child in that car seat, and I wouldn't expect her to. Not the way it looks now.
Now, we
according
don't
to her
know if it's the
pictures.
same child seat, but that's when I was looking at these pictures when the claim was first filed, and then I was looking at it last week to prepare. It's like, well, where was this stuff? In a basement, in an attic? So
Yeah, that does
So-
not make sense.
all right, so the helmet, the jacket, the skateboard, and the child seat certainly were moldy, but you don't believe they were stored in the house.
No, not in that condition. Not in that condition. I think they were stored in that garage across the street. They told me, Devin told me that he had bought that property across the street and was fixing up the garage and was cleaning up the lot. Well, I'm sure he did clean up the lot because that was,
All right, but you seem to acknowledge there was some mold because you hired a company to come in and deal with it.
I didn't know for sure. And I thought, we aren't gonna take a chance. So I hired expert cleaning to come in.
Well, did you ever go in and inspect the house yourself?
Yes, I did. I really did not see any mold. I had wiped some stuff down myself to look at things, to see if, and when it's wet, it looks one way, and when it's dry, it looks another way. You know, how most things are, like even this.
Yeah.
I didn't see anything major, but I said, let's get it all cleaned. So I hired expert cleaning to come in.
Is that the name of the company?
Yes,
Where are they from?
Kalamazoo. And they came out and they washed everything that was, took everything out of the cupboards. Because I was there watching them do it. They took everything out of the cupboards, washed the cupboards down with, I can't tell you the name of the stuff they were cleaning with, but it's to clean mold if there's any mold. And they washed all of that. And I watched the one guy, he was washing every bottle, box, everything. He was wiping them off that had been in the cupboard. Then they washed the walls and they washed the ceiling in the kitchen area. The entire room. And that had new laminate floors in, and they scrubbed that on their way out the door. Because I was out there checking on them to see what was going on.
All right.
Then there was a gentleman, another guy with the company, and he said he thought he saw some water build up on one of the windows outside. So he proceeded to seal that. And that was the $15.99, the bill for $15.99.
$1,599.
Yes.
Right now, she says they came in and spray painted everything.
Then she complained again. So I called Expert Cleaning and they said, okay, there's it's like a spray paint, but it's not really a paint. And it's for remediating mold and sealing everything. They came in and they sprayed the cupboards and everything. And she was right. He did not cover the food that he took out of the upper cupboard. He didn't cover that. So I called Expert Cleaning again and they said, we will take care of it. And they sent 2 ladies out and they scrubbed that kitchen from top to bottom and washed every cup and every bottle and every box that was in the cupboard. They were there 8 hours, 2 ladies working.
Right now, what about, this is the kitchen.
This is the
She says
kitchen.
there's mold just sitting in the middle of the bedroom.
Well, I can get to that in
All
just a second. And Expert Cleaning said, I'm sorry, we didn't get it done right. And they didn't charge me for that, which I really appreciated. So then we're still dealing with the mold. I asked Expert Cleaning if they had anyone that could review all of this, because they were still complaining about mold. And they said yes. And I contacted the Air Quality Corporation out of Lansing.
My heart's fine.
Here it is. Air Quality Mold and Moisture Assessment on North Parkville Road. I have that report. It's in your paperwork.
Yes, let me refer to it.
And they came, and again, I made sure I was there to see what they were doing. We discussed everything. And he set up air sampling equipment in the bedroom where the adults were, the living room, the child's bedroom, the kitchen, the family room, and they set up one in the crawl space. There's an area that's been dug out and then cement blocks built. So the well pump and furnace are there. And he went through all of that and the air quality results.
What exhibit are you referring to? I'm trying to get down to it.
I'm sorry. This is what it looks like, the first page. That's what it looks like. And then the results The results show normal environmental factors. They found completely normal bacteria, mold. The normal bacteria shows no human concerns. And you also see the only room that showed any extra particles were the bedroom where the adults slept. They called it the master bedroom in that report. And that was slightly elevated. But the final conclusion from him and the lab that he sent this stuff to, that there was, no, there it is. It shows the different counts in the different areas, but it shows counts in the dining room, outside, basement, which is that crawl space. Then the very last conclusion.
I'm looking for their final conclusion.
Oh, I thought I put that in the front, but maybe it's in the back. Yeah. It's page 6 of 6. Habitat found on decaying plant material and as plant pathogens. Effects, some allergenic properties reported, but general pose no health concerns to humans.
All right, and the date of this was in December of 23.
Yes.
So they moved in.
They moved in, I believe, September, October. I gotta look on the lease here. They moved in October 17th. And if you look at the receipts and the carpet in the stove and refrigerator, you'll see that was right around the 10th or something like that of October. It was just days before they moved in. So everything was new.
All right, so the carpeting and the stove, we're still dealing with this allergies, so this mold stuff. But
Yeah.
now, since they moved out, have you had mold problems with any new tenants?
No, none at all. I'm not sure. I suspect what they called mold might have been overspray or something. You know, like a mist from when they painted the house. We even had new doors and everything, interior doors put in.
All right, obviously the pictures show that I didn't understand what I was looking at in this microbial mold report. So you actually had a company come out and do an
Yeah,
evaluation
they came
of
from
the
Lansing.
property.
They came from Lansing and they couldn't find anything wrong.
All right. Now, let's talk. Now, I'm going to have you respond to those, Ms. Marchand, but she's indicated she had a company come out on 3 occasions and super scrub the place. She hired a company to come in and determine whether there was mold in there in December of 23, and they didn't find any. I'm also concerned that this, just a minute, this, when it's your turn, I'll ask you to respond to these, and that the car seat is all moldy, but there's not issues with other stuff in there. And there's been no issue with mold since you moved out. Now, she filed a counterclaim regarding the carpeting and the refrigerator. Let's start with the carpeting.
There's a hole in the center of the living room carpet. That was, I want to say it was around $2,300 for all the carpet. And I'm only claiming $1,000 for the living room because that's the largest room.
When I started my record label, the business side
Describe hole.
Oh, there's some pictures of it
Yeah, I'm
here.
trying to, I can, all right, here's new,
It's,
and
yeah,
here's, all right, it's torn.
it's torn and then, there's some yarn pulled out, almost full length of the building. Of the
Oh,
room.
it looks like there's a dark stain. Is that a stain or is that just a shadow?
No, that's a stain. I had the cleaning company come out and shampoo all the carpets. And they mopped the floors and everything. And that was the best they could do on that. There was an area about this big that was almost this color in the middle of the living room. It wasn't quite that dark, but almost. And there was also a spot in the bedroom that was like that. And they cleaned it. And yeah, you can see where the threads and stuff are pulled out
Yes.
in different places. I got a better picture on my phone, but I
Well, all right,
didn't.
let's talk about the refrigerator.
The refrigerator is all dented up. And the worst dent, of course, was on my cell phone picture and it didn't come out very well. But you can see some of the other dents in the refrigerator.
Does it still work?
Yes, it still works. Doesn't look very good, but it still works. The, you can, well, let's see. The stove and refrigerator were brand new. You have the bills for that. You can see the side of the refrigerator as, and the freezer door has a big dent in it. And the big door, where the refrigerator part is, that's got two large dents in it. And I took pictures with my cell phone and they didn't come out very well. But they're comparable or larger to what is on the freezer door.
So it was brand new.
Brand new. You
can
have the
see
bills
it.
for that.
Yes. All right, now, why didn't you include those in your initial retention of her security deposit?
Because at that point, I was glad they were moving out. But if they want to, you know,
All right, so once they sued you, you counterclaimed for that.
well, yeah, for the damages, which
All
I
right.
did not claim because I was glad they were moving out. Jessa was by herself and moving in with family was my understanding.
All right,
So
now
I
let's
didn't
talk
wanna
about,
I didn't want to be the ugly landlord.
how
also
much was
did-
the deposit?
Pardon?
How much was the deposit?
$950. And they were there 3 weeks beyond where their rent was paid.
So the rent was $950 per month, due on the 17th of each month.
Right. So
January 17th would have been the last rent that they had paid,
right.
and they were there till February 4th.
5th or something like that, 4th or 5th.
That'd be
So
14
approximately
days.
3 weeks was what I
That'd
figured.
be 19 days,
Okay. Also,
30, 65 per day.
in our counterclaim, it says reasonable attorney costs, and I did not get a copy of that included in this filing. I do have a copy of the bill.
All right, so there's a lot going on here, Miss Marchand. There's damage to refrigerator, damage to her carpeting. You were there for 19 days beyond when rent was paid. She is entitled to apply security deposit toward any unpaid rent, and other damage. She's supposed to give you a better explanation of what she's retaining it for, but she did return it. She decided not to sue you for the carpeting or the broken and dented refrigerator. Carpeting was obviously damaged. The refrigerator's dented, but it still works. And she went to great effort and expense to A, figure out the source of the mold, and B, figure out if there was mold. And this company says there is no undue amount of mold in the house. And she spent probably $2,000 or more trying to clean it.
Yeah, I spent $3,500 or $3,700 total. Also,
Just a minute. So you're looking at the Hayes report. We'll come back to you, Miss Marchand. What do you want me to know? Go ahead,
Me?
Miss Marchand. Yeah,
Sorry. I would like you to note on the Hayes report, it does say for each of the bedrooms that they are reading slightly higher or significantly higher than baseline.
well, I don't have an
They're
expert here to
highlighted.
tell me what it is.
Are you looking to
And they did there, so there was one company as well that came in and did say that there was a massive mold issue and that like they said that it was probably in the walls and she didn't like that response. So then she went to someone else who told her a better answer that would tell her that she didn't have to spend as much money.
All right, so there was another company that did an analysis?
That was the first initial company that caused all the havoc.
they did the cleaning.
He came in
That was
and
the cleaning company.
said that there was mold in the walls and that the walls should probably be taken apart and everything should be fixed in that sense. And we never heard anything about that again because that company never came back out.
Can you tell me the
All right,
company name?
stop. Yeah, so she talked about expert cleaning. Is this somebody other than them that came in and did an analysis?
Yes. So honestly, I don't know any of these company names. I've just was told that they were coming in to clean that house that we were living at. So these names are new to me. So that's kind of a little bit hard to navigate, but yeah, I'm trying to figure that out. The one that I do remember specifically is Bailtech, and she doesn't have anything from Bailtech in here. And they put like some weird mechanism in our house that like was supposed to filtrate the air, but I think it honestly made it worse.
I can explain that.
All right. Now, the air quality consultants that are in here, I don't know what these numbers mean. The living room.
Yeah, I don't either. I was just reading the ledger at the bottom.
Mm-hmm. Well, and I don't know what I'm looking at. Significantly higher than baseline as to aspergillus and penicillium. I don't know what this means. There's no overall conclusion regarding the quality of the air. If I'm looking at some of these correctly, it says they're significantly higher than baseline for these allergens.
Correct.
Penicillin, they're telling you what it is, but that's not.
Yeah, red. The spore count is significantly higher than baseline count and probably indicates a source of contamination. There's lots of red in this report.
Yes.
What page are we on?
There's a staple in it, page 3 of 6.
Okay,
And then page 4 of 6
Mhm.
that indicates what the different things mean.
And you will see that the master bedroom is where 90% of the problem is.
Well, living room shows 890,
Right,
significantly higher than baseline. Master bedroom, 2,600,
right.
significantly higher than baseline. Kids room, 290,
That was the cleanest room in the house.
significantly higher than baseline. Kitchen, 390, significantly higher than baseline.
Mhm.
Dining room, 210. I don't know what baseline is. Basement, 2,300, 250. They're all significantly higher than baseline.
But I don't know what baseline is either.
Yes, so this report isn't helpful to me without having an expert, but it looks like they found mold higher than baseline in the dining room, basement, master bedroom, living room, kids room, and the kitchen. Now, to your credit, you spent a lot of money trying to remediate it.
Yes, trying
and-
to be responsible.
Yes, all right.
Man,
It was only that one compound or one,
Well, if we were in a real trial, not in small claims,
right,
that report wouldn't be admissible without a foundation. There would be someone here to explain it.
yeah.
It's admissible in small claims court without the big foundation, but I don't know what any of it means. It lists a number of organisms. The only ones that they show
Basically are the penicillins.
Asparagus, and I don't even know what that is. I don't know if that's,
It's a common organism we have in the environment.
and
That one
then,
I do know.
Mint is still $15.
I guess the overall point is I have tried to be responsible and respond to any of their complaints.
well, you certainly have indicated there were multiple efforts to remediate this. All right,
Also, one other thing, I don't mean to interrupt.
you keep interrupting.
I know.
We are in small claims court, not a regular court, but you keep saying stuff, talking over me and speaking as though we're talking around the kitchen table. I'll come back to you when it's
Okay.
your turn.
Okay.
All right,
One more thing.
you were miffed, for lack of a more appropriate term, that she didn't give you your whole security deposit back. Did you ever cash the check?
absolutely not.
And she didn't send the security deposit notice that's supposed to tell you why she's retaining the deposit.
Which I would have
So
been a
that's
little
what's,
more understanding if I
that's what
would have gotten
started.
reasoning, sorry.
All right, now, what concerned me when I was first looking at this stuff looks bad. But why didn't everything else look bad? Why didn't the couch look bad? Why don't the drapes look bad? Why don't the bedding in the child's room have this same sort of issue as opposed to just a child seat that's sitting there? So what's your response to that?
I do have proof of where I found everything and where it was in the house. As far as, I don't know why everything wouldn't be covered. I just want to know why my stuff is damaged that is. I don't really have an answer as to why not everything was covered. I can tell you that the windows in my daughter's bedroom also had mold on them. I found a dead bee in my bedroom on the windowsill that was completely encased in mold. Just random stuff would mold. Like anything that we pulled out for winter use that was put away in our bedroom, for the summer, we pulled out for winter to use. And that's when we discovered our coats were all moldy. We had to go buy all new winter coats. Hats, shoes, socks, just anything molded.
Well,
I had
obviously,
necklaces that molded.
the place looks great. The before pictures, and she indicated they spent tens of thousands of dollars to redo the place. Everything was brand new. And everything looks great. The carpet's new, the walls look nice, the doors are in molding, the ceilings, everything looks great. The kitchen looked good. This was a nice place. I could see probably why you were willing to rent it, but it's an old house and it may have some problems in the walls. I don't know. I don't know what that mold and mildew report tells us.
Might I also add that when we moved in, she said that there was prior mold in the house and they had it taken care of. And there was still some stuff on the cabinets and I addressed it and she said to clean it. There was also mice poop in the cabinets when we moved in and we were told to clean that as well. We lived with mice, setting mice traps the whole time we were there and they told us to keep the mice and put them in the freezer so they could feed them to their hogs. And we did not do that.
Frozen Moses. All right. All right. Now I'll give you a final say and then Ms. Marchand, I'll give you the last word because you're the plaintiff. Ms. Butler, you had some other things you wanted to tell me?
Item number 17 in the lease said the landlord is not responsible for injuring tenants' personal property and encourages the tenant to procure a policy of renter's insurance to cover and insure tenants' personal property. And the bottom of that page is initial. And I go over every one of these with the people when they move in. Doesn't matter who it is. I go over every one of those things because I wanted to make a point that I do not want smoking in the house, things like that. And this is just a standard lease.
Well, it is, but you left some part of it out. Damage to tenant's property. Landlord will not be responsible for any damage to theft, loss, or destructions of tenant's property unless.
Has Kyrie texted you back?
The damage is caused by landlord's negligence or fail to maintain the premises as required by the lease. There's something called a basic covenant of habitability where the
Yes,
property.
and you can see I did everything I could to ensure the house was clean and proper. And getting the air quality people was above and beyond what normally would happen.
Yes, and I don't know what their report tells me, whether there was a problem or whether there wasn't.
Well, the gentleman called me personally and said, there's really no problem in the house. We couldn't find anything other than normal environmental bacteria, mold, and things like that.
All right.
And as far as another company coming in, that Baytech or whatever, one of the guys that worked for Expert Cleaning had worked for Baytech, and he said, well, I got an air purifier. I'll bring it in and we'll just let it run for a while. That was that was why that was there, and it had the Baytech or whatever name on it, because it was the company he had sold. And then he went to work for Expert Cleaning. He's also the one that sprayed inside the cupboards and didn't cover any of the food. So they came out and cleaned again.
All right.
So we've had a clean house to start with. I've cleaned and cleaned, had people clean and clean. We've had the air purifier running. We've had extra testing done. And the people that are there now have no problems whatsoever. Because I told them about this and asked them specifically if there was any problems, any place they needed anything done. They said no. And also I did not include the attorneys bill
Yes. Now,
with the
you did
original.
include the refrigerator bill. The refrigerator's dented, but it works.
It still works. But it's dented, and you know how that looks to the next tenant. I just told him, I said, the guy that lived here had a raging temper and damaged things. There was some damage to the paneling in the family room also. I didn't even bother with that because I'm not gonna remove it and have it painted. There were some other things that were nailed into the floor and the wall. We had to have that removed. But I attempted to please these people and keep them happy and healthy the best I could. Also, as far as the temper and stuff goes, it was bad enough that I was threatened a couple times. Normally, I would turn and walk away, but the way Devin was raging, I was afraid to turn my back on him. And his dog came in and stood between us. And I told him, I said, your dog's looking at you. And then it was kind of like it broke the spell and he calmed down.
Well, he's not enlisted in here.
He's not listed in here, no. But he's on the lease.
Lease clause 17 says you're responsible for damage,
Right.
the tenant. And her counter to that is, in addition to that, I hired expert cleaning services in the fall of 2023. I hired the air quality people to come in.
Yeah.
In December of 2023. She had work done on the HVAC system in.
Yep. Just because I was told by the furnace fella. They said it didn't run, so I had the furnace guy come out and he said there was one part, but he said we always change filters and things like that. And there were extra filters for Devin. Excuse me.
All right, so the
To
property.
change filters in the furnace.
All right, Ms. Marchand, anything else you want to say?
The Bail Tech company was actually a separate company. I don't know what she was saying, that he had something that he was selling something, but that was, they came out with Bail Tech trucks. So I don't know, that was a little confusing.
What did
And I
they
think I
do?
did also, what?
What did they
That
do?
was, I'm pretty sure that was the guy that came out and said that the walls needed to be removed and that they gave her a certain price and she didn't like that price, and that they gave her a second option that was cheaper and less efficient to actually get anything. He actually did explain that to us. He was like, I'm not supposed to say this, but this is the less efficient option that they're taking to get this done. And I was like, wow, that makes me feel a lot better. And I would like to also add the items that she does not think that were stored in our house. I do have pictures of every time that I found those. The skateboard molded to the carpet in our bedroom. That's how I found it.
All right, anything else?
From either one of us?
I gave you your last word. This is her
Okay.
last word.
That's what I thought.
Other than I just didn't understand why I couldn't get a proper refund of my deposit or a proper notice.
Well,
of why
she had legitimate reason to retain your refund. She didn't
As
do
far
it
as
right.
And as well as the staying past not paying, I have a witness as well that was there that she said, she stormed out and said Merry Christmas and said that we were good, and she said that we didn't have to pay. Because I argued with her about having to deal with all this headache, and it's just not something that someone should have to go through in a living situation. I think that I should sign a lease and be able to live there comfortably like I am now, and not have to worry about my living situation.
Well, the fact is that you stayed beyond the rental period. Those are things that she can apply the deposit to. Under the Landlord-Tenant Relationship Act, you're supposed to.
Yeah, I have a witness that heard her agree to saying that
Well,
that
the
was
witness
okay.
the witness isn't here. This
She
is a
actually is
trial.
in with me.
Oh, all right. Well, bring that person into the screen.
She said that we were good to not pay.
Hello.
Good afternoon. Why don't you trade seats? What's your name?
Shirley Jordan.
Ms. Jordan, will you please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes.
Ms. Marchand says you were there during the conversation between Ms. Butler and Ms. Marchand at the time they were moving out. What do you know about that?
It was a time that we were having an issue.
At the time they were having the issue and Sharon was there.
All right, well, what do you know about it?
I heard her say to Jess that, okay, you won't have to worry about it. We'll take it up in January.
I don't know if that was right month.
Well, just a minute. Jenna, don't tell her what to say.
I'm not, sorry, I was just telling her it was the wrong month.
Well, that's not up to you. She's the witness and she's under oath, and so I'm stuck with whatever she tells me. What else do you know, Miss Jordan?
That's all I heard when I was there, because Sharon was getting ready to go out of the house.
Thank you. You're good to go.
Thank you.
All right. Let's see if we can come up with some sort of an answer here. The counterclaim is for $1,000 for the carpet, which is a portion of the $3,300 total cost, and $738 for the refrigerator, which was only dented. I don't know how to assess that cost. The carpeting, I'm comfortable with. The refrigerator, how much is a dented refrigerator? I don't know.
You want to file free? Hit it.
Let's say $200, $1,200. All right, now, she kept part of your $950 deposit. They claim that $700 was for rental debt. That's not accurate. It was 14 days in January and 5 days in February. So that's 19 days. Rent is $950 per month. 15 or 14 plus 5 is 19 days times 30 or 950. And it depends on whether we use 30 or 31 days, but I'll use 31. Divided by 31 is $30.65 a day, give or take, times 19 days is $582.25. That's how much was unpaid rent, which can legitimately be taken out of the security deposit.
I do actually,
I didn't ask you a question. We're done taking testimony, so I'm just making a ruling. Although she didn't do it right, so arguably there's a claim for treble damages regarding the security deposit, but it wasn't requested or pled. Then we've got the defendant's or the plaintiff's claims for these properties, which were damaged due to mold, which I believe they were. But she wants brand new replacement property for stuff that's used. This is an old used skateboard. She did provide pretty good documentation of each item. The child seat, $299, the tech hoodie, $119.95, the helmet, $79, and the skateboard, $136.99, and the air purifier or I'm not sure what that thing is, $329.99. The total of those was $895.51. There's $1,000 in the counterclaim. I'm going to allow $200 for the dented refrigerator, $582.25 for rent. So let's add that up. 1,000 plus 200 plus 582.25 plus 1,782.25. The plaintiff is requesting the return of her security deposit. She gets $250. So the deposit was $950. The plaintiff was entitled to retain $582.25, which leaves $367.75, and she paid $250. So the plaintiff is entitled to an additional $117.75 from the deposit. The items that she claimed were $895.51 equals $1,013.26. However, the plaintiff has already recovered the $582 of unpaid rent from keeping the security deposit. So I'm allowing $1,000 for the carpeting and $200 for the dented refrigerator. The security deposit was applied to the unpaid rent, so you've already covered $582.25. You overtook $117.75, and I gave the plaintiff everything she asked for regarding the moldy property. And her there were other things that were not included, like your attorney fees, whether there was an issue of treble damages, the other property the defendant lost. You had additional expense in trying to remediate this. Ms. Marchand, I don't disbelieve you. I don't think you wove this out of whole cloth. I think there's a mold problem at this house. Ms. Butler attempted to do something about it at considerable expense. I think they know there's a mold problem at this house. I don't know why there would be a mold problem when you were there and there's not a mold problem when the new people are there. I don't know. But this comes out almost as a wash. I find,
You have the attorney's bill, if that helps.
no, it doesn't, because I'm not ordering it.
Okay.
Someone who's not here is the co-tenant, Devin, who I think caused the majority of this damage. But Devin Russell.
Base 44 super agents. Careful, there's no going back. No setup. Just say hello. Every tool you
give or take. I allowed $1,000 for the damaged carpet, $200 for the refrigerator, which is $1,200. From the plaintiff, I allowed $117.75 of additional deposit that she did not recover. And I allowed her damages that she claimed for the mold of $895.51 plus her court costs. So $1,096.93 is what I would give to Ms. Marchand. And I would give $1,200 to Ms. Butler. So we subtract 1,200 minus 1,096.93 equals $130.07. I find for the counter defendant the amount of 103.07. Ms. Marchand, you started the action. She filed a counterclaim. I discounted both sides' requests, although I gave you everything you asked for regarding the mold. But I didn't award treble damages regarding the security deposit. Who did your pleadings? One of the attorneys in Vicksburg?
Yes. Yeah, Lauren.
Yes, and they had represented you in the past, which was helpful. And the lease is good, but you need to make sure you have a better understanding of your obligations under the Landlord-Tenant Relationship Act.
Okay.
Ms. Marchand, you owe Ms. Butler $107.03, and you get none. It almost came out as an exact wash, but not quite. So I'm going to do a judgment for the counter defendant. I won't have time to do it. We'll send it to you each in the mail. For the counter defendant, the amount of 10. When did it become a thing that the assistant prosecutor could come in and tell the judge that he's disgusted by a ruling that he made? I'm not sure when that became appropriate. Well, we've got almost everybody we need. Is Mr. Gabriel going to come?
Your Honor, I have not gone out and spoken with him after I sent that email. I was hoping.
I don't wish to do this in chambers. I wish to do it on the record.
Is this the show cause or contempt?
No, it's just we're not there yet. I just want to make a record of what happened. If I get an appropriate apology, it'll be the end of it. But he needs to be accountable for his actions, and I'd like to speak to him about it.
Speak with him and get back. Your Honor, Mr. Gabriel is willing to come in and speak with the court. We would ask that it be off the live stream. It can still be an open courtroom, but we would ask that it not be streamed.
All right, thank you.
Thank you.
Come.
I don't know what we're waiting for.
We're waiting for Mr. Gabriel. I'm
Is
not
there
sure.
another hearing in a different court?
I'm sorry.
I thought it was done.
He is, I guess I was hoping the court would address.
No, I'm not doing it in chambers, and I'm doing it on a live feed. If he doesn't wish to be here, we'll make a record. I'd like him to be here. He had a position he wanted to state. I never got a chance to explain my position. So no, if he doesn't wish to be here, then I'm gonna proceed accordingly.
Kendra,
Um,
we go. Take care. Okay. As far as Mr. Fuller's case, is there a drug test that?
Well, I called, we'll address that when everybody gets here. We can't do an instant drug test because we don't have a male certified to do it. We only have Autumn. So I'm gonna send him to the day reporting center directly from here. There's a condition of your bond that you test on demand of any police or court officer, prosecutors asking for a drug test. I would prefer to have done an instant one. We did one yesterday, which we're gonna deal with in a minute, but I don't have the ability to do that. So when we finish here, you're gonna go directly to the day reporting center and test, and then we'll deal with the results of your test either when we get them or at the time of the prelim, which is set for next Tuesday at 1 o'clock.
Yes, sir.
All right, good morning. Mr. Jeffery is here, and we're gonna proceed. This is in the matter of Peoples versus Karan Duvar Fuller.
Your Honor, this is on the record, the light.
Oh, yeah, good, thank you. Thank you, Deborah. Laura came in to check. This is in the matter of People versus Karan Duvar Fuller. Mr. Fuller is here with his lawyer, Mr. Ross Truckee. Also present is Assistant Prosecuting Attorney Gary Gabry and Prosecuting Attorney Deborah Davis. Mr. Fuller was charged in April with being a felon in possession of ammunition. I believe that alleges he had 2 shotgun shells. Anyway, because he is a felon, he's not allowed to possess ammunition, and the matter was charged as a felony. He is on bond on 3 other felony cases, which are all bound over to the circuit court. And he was charged with this. Judge Pattison set the bond at $10,000 cash or surety with certain conditions, including supervision of the Community Corrections Office and drug testing. The defendant was here on, I believe, May 13th for a pre-exam conference with Mr. Truckee and indicated at that time he wished to have a preliminary examination. So the preliminary examination was set for May 20th. And I'm going to represent what I was told so anybody can correct if it's different. At any rate, the defendant didn't show up on May 20th. Police officers were here prepared to testify, much to the consternation of all of us, including me. So I issued a bench warrant and set bond at no bond. I wanted to see you personally. Then I went on a trip. I came back on Tuesday, May 27th. I believe it was, this occurred the following day. I may have my days mixed up. I thought it was Wednesday, the 28th. At any rate, there was a warrant out for Mr. Fuller's arrest for failing to appear at that hearing. He called the court that day after the 20th and said, in the afternoon of the 20th, so I missed my court date. And they said, well, there's a warrant for your arrest. Between the 13th and the 20th, Mr. Fuller came into the court and paid some payments on a payment plan that he was on for some other cases. So between the 13th Tuesday and 20th, they didn't show up. He was actually in the courthouse and paid on some fine. So
You sneak across the border, be prepared to be sent home.
he didn't show up on the 20th. Then he presented himself at the court. Now, Mr. Truckee or Mr. Fuller, you can fill in the details here. My understanding is Mr. Truckee told him to turn himself in at the jail. Rather than meet him here at the courthouse, Mr. Truckee was here that morning. He told him to turn himself in at the jail. My understanding is, and correct me again if I'm wrong, he went to the jail, and sat there for about 45 minutes, but they said they were too busy to book you in. Is that true?
Yes, sir, Your Honor.
So you came from the jail to here. So I'm in the middle of a busy morning with a bunch of other stuff going on, and here you are. So you walked, Mr. Truckee walked out the door, you walked in the door. So he was gone. We tried to call him, but he was already on his way to Three Rivers. So here you are. I canceled your bond. It was my bench warrant. And there's a statute that nobody likes. But it's MCR 6.105. It's actually a court rule. If a defendant wanted on a bench warrant or arrest warrant voluntarily presents himself to the court on that warrant within 1 year, the court must either recall the warrant and schedule the case for a future appearance. It is presumed that the defendant is not a flight risk when the court sets a bond order or other conditions of release at arraignment. So that's what I did. There was another option. You can arraign the defendant if the court is available to do so within 2 hours of the defendant presenting himself. So he'd been to the court between the dates. He called the court the date he missed. He went to the jail to turn himself in. They wouldn't accept him. So I went with option 2 of the court rule, which allows him to be presumed to not be a flight risk and appear, which he did. Mr. Truckee was scheduled to be here this morning. He was late. He did call and said he was running late, but he's here. I didn't give him a PR bond. I simply recalled the warrant and reinstated the $10,000 cash or surety bond that was in effect. So it's like, okay, no counsel was here. Mr. Stickley wasn't available. Mr. Truckee had left. I didn't give notice to the prosecutor. I simply scheduled the matter for this morning. And then went on back about my business because I had other stuff to catch up from being on vacation. So some point later that morning, Mr. Jeffery came into my chambers. I was in there signing some orders and I said, hey, good morning. I got something I'd like to talk to you about. I had a misdemeanor complaint that was handled by their intern that I wanted to check with him on. And he said, I have more important things to talk about than that. And he said, why in the hell would you give Karan Fuller a PR bond? And I didn't have an instant response, but I didn't give him a PR bond. I just recalled the bench warrant. And then I said, well, I guess I'm sorry I didn't give you notice of the proceeding, but he just showed up and I cited the court rule. So I set it for today. So Mr. Jeffery was quite upset. He got up and either said, this is disgusting or you're disgusting. And he walked out of my office. And this was ex parte. Nobody else was in there but us. And so I left sitting there thinking either me, now maybe the statute is disgusting or court rule that there's a presumption if they turn themselves in that they're not a flight risk. If I had done that when I was assistant prosecutor to Judge McManus, Bob Karras would have fired me that morning. When did it become a thing that the assistant prosecutor could come in and tell the judge that he's disgusted by a ruling that he made? I'm not sure when that became appropriate. I don't believe you do it to Judge Stutzman. I don't believe you do it to one of the judges in Kalamazoo. I followed the law. I had an understanding of the facts. I followed the court rule. I set the matter for hearing. He's here today. The offense he was released on was possession of 2 shotgun shells. I don't have the discretion to cancel this bond because Gary Jeffery is mad at him. And I didn't deserve what you came in and said to me. In my career as judge, you've been the most disrespectful attorney to me, bar none. An attorney came to me after a hearing and said, How long do I have to be a lawyer before I can be as much of an asshole as Gary Gabry was to you? I don't deserve that, and I didn't deserve this. I followed the law. I had a better understanding of the facts than you did. I had a better understanding of the law than you did, and he's here now.
In a world filled with noise, true strength.
Make a motion to cancel his bond in circuit court if you're that upset about it. I'm going to send him for a drug test here before we're done this morning. This violates the canons of professional responsibility. You have an obligation to treat the court with respect and your other lawyers with respect. And I understand that you were upset, but you left before I even got a chance to explain myself. So that isn't a thing. The assistant prosecutor can't go into the judge's office and say, your ruling sucks. That's not how it works. So I didn't deserve it. I don't deserve it. And I believe I was right. And he's here now. We're going to have a drug test. You have your right for a preliminary examination, which will be next Tuesday at 1 o'clock, and we'll proceed accordingly. So what I expect is you to apologize. I understand that you lost your temper and you're upset about it. And that's to be understood. Nobody liked Court Rule 6.105. It was very controversial with the judges. You either had to let them go or drop everything you're doing and arraign them within 2 hours. And as I said, he had turned himself in at the jail and they wouldn't take it. So I set it for this. So that's all I have to say on the matter. Ms. Davis.
Thank you, Your Honor. First, I would like to say that we were not aware of Mr. Fuller attempting to turn himself into the jail. But that's the first I've heard of it is today. We'll certainly be following up with that. Our belief is that the bench warrant arraignment is a critical stage and that he should have had an attorney. We had made it clear at the last hearing when the request was made that we felt that Mr. Fuller was a continuing risk. He was involved with felonies. He's not new to the system. He knows how this works. He knows where he's supposed to be and when he's supposed to be there. His pattern of behavior towards law enforcement is extremely dangerous, with fleeing and eluding and resisting and obstructing. And in order to protect society and give our law enforcement the support that they deserve too, we were asking that his bond be canceled and that he be remanded. The concern is now that he continues to be around people who use substances. So his history in not showing up, I'm thankful that the court is going to have a test done.
Well, let's assume that all that is true. What gives him the right to come into my office and express his disgust for my ruling?
Your Honor, I don't believe that it's not appropriate. I get that. We are in a very difficult situation in our office in light of everything that has happened in the last year and a half. So it's been very difficult. It's been very stressful. And I think overall, Mr. Jeffery has the same philosophy that I do as far as holding people accountable and taking action so that people know that if they do get in trouble, we're going to hold them accountable and not just allow people to waltz in as, when it's convenient for them. It's not convenient for any of us. And, we do our best to have somebody available at all times so that if there is an emergency hearing, the court can call down and we will get somebody here. So what happened, the way it was described to me was different than what
well, there's two sides to every story.
Correct, and there's perceptions. So I know that Mr. Jeffery apologizes for the.
I don't want to hear it from you. I want to hear it from
Well,
him.
I understand it. We'll give him a chance to speak in just a moment. But from the beginning, it was my understanding that the comment was made as far as the whole process, because we feel like we're doing our best to charge, hold people accountable, and show up whenever we can.
Well, we've got a case where he's charged with possessing 2 shotgun shells.
Which
Move to cancel his bond in circuit court. If you could, I don't want to hang my nail on canceling a bond for someone who was here in between, called the court, went to jail. And the law doesn't require that I give notice to the prosecutor. I had one of these yesterday. I have one almost once a week. Somebody shows up. So he's here. You're right. He keeps doing stuff. Or try one of the cases. He's got 3 cases bound over to circuit court. He got charged with a crime, got arrested again. No motion to cancel his bond in circuit court. We set his bond at $10,000 cash or surety with conditions. So it isn't like we're just saying, you know, please don't do this. But it would have been an abuse of my discretion to cancel his bond for not showing up on a case where he possessed 2 shotgun shells. So I set it for this hearing. And he's here, and we're going to drug test him. And you can have a prelim next week.
Want to flush out its swollen legs? Stop doing this first.
Thank you, Ron.
Mr. Jeffery.
First of all, let me say without any equivocation that I apologize for losing my temper, for addressing you more as someone that I have known for my entire career in criminal justice, someone who with me taught a number of even elected prosecutors right now how to try a case, how to be a prosecutor, what the ethics are involved in prosecution. In my 45 plus years, I have never been held in contempt. I have never disrespected the court when on the record. I have always prided myself on not only doing the right thing as a prosecutor, but also protecting the community's interests and law enforcement's resources. The comment that I made to you would never, Your Honor, and I think you know this because you and I know each other, our wives know each other, we've spent time on Mackinac, would never indicate my disgust for you as a human being. I have the utmost respect for your career. I do, however, differ with some of your handling of matters, one of which is your live stream. And you are aware that I took an opinion about that the last time I was here. I still come to court when I can. I was brought in here to handle circuit court with the idea that this office might be able to get back where it should be before the last prosecutor dismantled things with his blatant accusations against my present boss. That's why I'm back here. Because I believe in this prosecutor. I believe she's the first one you've had in a while that wants to do the right thing. And the right thing, just like it was the first time I was here for a while, was to hold the people that are putting a huge burden on the citizens in this community, to hold them accountable. My anger and my disrespect was directed towards a feeling that I have that this court expects a lot of its prosecutors to be here, to just wait, to address things that, as I just conveyed to the chief judge, one of the few counties I've ever been in as a prosecutor or a defense attorney where prosecutors appear routinely at sentencings. It just doesn't happen anywhere else. Why? Because they're busy. Well, we're busy. We have 3 people. One of them is the elected prosecutor, the newly elected prosecutor who has her hands full, just trying to correct the errors of the past year. That leaves me handling circuit court and helping out in district court, while Mr. Robert is helping out in district court and also spending a lot of time in Three Rivers. So yes, there is a lot of pressure on this office. Did that enter into my feelings of disrespect for how this system operates? Yes, it did. It was never directed towards you, Judge Middleton. There are times when I lapse and I have to think to myself to say Judge Middleton, because we've known each other a long time. I will, if I can, be honest now, not that I haven't been up until now. You will recall that while at that prelim, I came in here and I advised the court right away that I had been working and trying to get Mr. Truckee to let me know whether Mr. Fuller was going to waive or not waive, that I had talked to Mr. Truckee about what would happen if I'm going to have to bring officers to come in and sit as what you call kind of so what case. Well, they came and they waited and they waited and we waited. I looked at this young man's record, this 34-year-old man, and I saw bench warrants just like this on the Walmart case and the stolen car case, where he was supposed to be here. And it got adjourned, come back. I think Rhonda Ives, no bench warrants issued. In this situation, what happened from our perspective that day was I appeared at the prelim. I respectfully laid out why I thought it was appropriate that his bond be canceled, that a bench warrant be issued so that he could be brought before the court. And I knew he was going to get another bond, or at least we might find out, A, is he around? People assumed he was. I don't assume anything. All I know is he was supposed to be here. You did a bench warrant.
This records conversation.
I checked when you were gone because Mr. Robert pointed out the ROA was confusing, that it sounded like he was to be something about arrest, but the warrant was there. So I talked to Judge Pattison. We went to the district court. We clarified the day before he walked into court that the bench warrant was valid. Mr. Truckee had told him to go to the jail. And I knew nothing about him coming in here. Certainly knew nothing about him going to the jail. I knew nothing about him coming into the court when there was a warrant and nobody in security notified us. What I was notified of was when my prosecutor walked in that morning and said, I just saw Karan Fuller riding a bike or something down the street. What's going on? So I go up to security and they tell me, oh, he came in and Judge Middleton let him go. That upset me. It upset me because I thought that because of the respect that I've always shown this court, my willingness to try to be here to do what I can to help out, that I would have been notified of something when I'm sitting in my office looking at my cases. I want to know why he wasn't here. That's usually what happens in circuit. They get arrested. Why were you here? Well, my mother was sick. Okay, we'll reinstate the bond. Something to impress upon people that the court means business. And that's all I ask as a prosecutor, that the message that gets sent through this live stream, through our appearances in court, means something. Not comments like on the record, well, it's not the crime of the century. Or it's a pain in my neck when this happens. Pardon me?
Yeah, he is a pain in the neck.
But he's more than that, Your Honor. He shows disrespect to you, too. Your statement that you made about, well, it's more trouble to book you in and then book you out.
That's true.
It is. But that's the system that's in place,
all right,
isn't
listen,
it?
I agree with everything you said.
And let me finish and then I'll take my admonition. I do not recall that you ever indicated, or that I indicated a PR bond. I didn't know what happened. All I knew is you let him, they told me that you let him out. I didn't hear the court rule cited whatsoever. That, I think, would have been the thing that we might have done on the record had he been brought in and Mr. Truckee held here or held in the jail and held in lockup until Mr. Truckee got back, because I'm interested to know what kind of contact, if any, he even had with his attorney after he walked out of here. Those are the kinds of issues that go into my decision on whether I'm not going to use additional resources to just simply file a motion in front of Judge Stutzman and bring Ms. Ives in and bring everybody else in because of the multiple attorneys that get involved here. So there are a lot of things that I like to discuss. And I think if you talk to the chief judge, you'll hear that we talk about ways to try to improve the system, to try to make it more efficient, to try to make it work with just 3 of us. So yes, I was angry. Yes, I regret my comments to you, and I regret losing my temper. I don't want to be seen as that way, but I have been doing this for pretty close to 50 years, and I've seen it all. And I've been a judge dealing with parolees going back in front of me on the pro board. I know what it is to disrespect someone, and I feel bad that I did that, and I feel bad that I did it to somebody that I in the past considered a friend. I hope you will accept my apology for that and recognize that the frustration that I have is not because I'm lazy. It's not because we don't want to be bothered. It's because we want to try to make the system work for the people in this county, the people that are paying a lot of money. My last comment that I wrote down when you were talking is what you said about the court rule. And I will say, I don't have that memorized. I haven't really experienced that before. Nobody's ever cited it to me. The way it's been handled is what I just outlined. Come in, hear your story. Why didn't you do? Ask the defense attorney, what kind of contact did you have? Usually there's the admonition. I'm going to let you out. You're going to be in touch with your attorney. You're going to be on time, not 10 minutes late for court, like this morning.
We went through that.
Okay. And is he, not presumably a flight risk? Let's not forget that this case, in which he faces life or any term of years because of his past record, is right on the heels of a case in which he led law enforcement through this little town in a high-speed chase while he allegedly was carrying meth and a gun. So this man is bordering on heading into a lot more serious. And it seems to me, and again, I'm not going to go into comments that you and I had off the record about your past dealings and family's dealings with Mr. Fuller. But yes, I was upset because I have a perception that this is not being treated seriously. And for that, I apologize.
All right, your apology is accepted.
Thank you.
Within the week, Judge Pattis and I had a discussion just before I went on my trip about what an asset you were to the prosecutor's office. You can try a case in circuit court. You're willing to do misdemeanor pretrials. You show up at sentencing and do appropriate, thoughtful comments. And Judge Pattis and I both believe, I'm sure Judge Stutzman too, that you're an asset to your office. The office wouldn't function without you being there. You and I go back 45 years, which is in part why you thought you could come in there and unload your anger on me. Yes, we taught a generation of young prosecutors how to be a prosecutor, including our current Attorney General. But this case isn't the one to hang it on. Now, we'll have a drug test, and I have my suspicions of how that's going to turn out. And we'll have a prelim, if necessary, on Friday. When all the cases are in circuit court, perhaps you can file a motion to cancel this bond. But that's up to Judge Stutzman, and he's got multiple counsel. I think there was an effort to try to do everything together. Anyway,
Your Honor.
I regret that this whole thing happened. I discussed it with the chief judge when he got back, said, how should I deal with this? I don't think it deserves a grievance. All I wanted was an apology, and I got one. And the case will move forward, and the defendant is here as under the court rule. I said, nobody liked that court rule. It was probably the least popular in the whole criminal justice reform package, but I'm bound to follow the law. Yes?
You had mentioned the prelim on Friday.
Excuse me, I'm sorry.
Okay, I just want to make sure.
No, Tuesday, I don't want to make any further confusion. Tuesday, June 17th, 1 o'clock, Mr. Fuller, you're to be there at that time. I want you to go directly from me.
I'm sorry, June 17th or the 10th?
Boy, I'm all screwed up. June 10th, next Tuesday,
All be on the same
June
page.
10th, not the day we've been using for the others. I want you to go to the day reporting center right now, and we'll do an 11-panel test. We'll figure out who's going to pay for it, but it'll be paid for.
Yes, sir.
Then it may take a few days to deal with that. We'll deal with the results of that at your prelim next Tuesday. All right, you're free to go. We'll let the day reporting center know that you're coming. Laura, will you call them and tell them Mr. Fuller's going to stop there for a 11-panel urine test?
Thank you, Your Honor.
Thank you, Your Honor.
This matter is completed. Let's bring Ms. Welch in and deal with that matter.
Base 44 super agents. The next thing you can't live without. No setup. Just say hello.
Jim, I'm afraid you're going to hurt yourself or somebody else, or somebody's going to shoot you. And if you get off on these rants.
By evaluation, I'd say you're incompetent and you stay in jail for a year and a half. No, you don't have to worry. Just have to.
Good afternoon, Mr. Roberts. This is Judge Middleton. Can you hear me?
Yes, Jeffrey.
I'm fine, thanks.
Oh, Jeffrey.
We got to get your case back on track, Mr. Roberts. Also with me is Mr. Stickley from the Public Defender's Office and Ms. Camfield from the Prosecutor's Office. You missed a court date last week, and we need to get the case reset.
Okay.
So
I talked to my lawyer and stuff. I talked to 3 or 4 lawyers. I got the information and stuff. That I was home. I was held here 8 days. I was only home 2 days. I was told to stay home and not leave the property, and that's what I was instructed to do, and that's what I did.
Well, you missed your court date. Your lawyer was Jordan Harden. I'm going to reset.
It's not a court date.
Reset it for September 23rd.
Okay.
25 at 8:30.
Okay.
And I'm going to set a prelim for 9/30/25 at 1. Mr. Roberts, who posted your bond?
I don't know.
You had a $4,000 cash or surety, 10% bond. Somebody put up $400 to
I
get out
have
of
no
jail.
idea who did that. I went to try to talk to my sister Stacy because to get my dog, my German Shepherds back, and she's on my bank account. And I went to get my dogs back, and she told me to go away. I was like, all right, maybe she's upset or something, maybe something I did, but she won't.
Why don't you
she's
take
in
a minute
charge.
and put your shirt on, all right?
I haven't even been booked in or anything.
All right, well, we'll get squared away here.
I'd like to Fred Taylor. I talked to him. He's supposed to call Fred in uptown at Ross Truckies. And
Well, they
yeah.
appointed Jordan Harden as your attorney, and we'll reset this.
Yes, sir.
All right, Judge Patterson wasn't very happy. He didn't show up. He set the bond at $10,000 cash or surety.
I didn't have anything in the mail or nothing. I didn't even know about it.
Well, that's what the other guy said. Now, you also have a new charge. You got arrested last night or this morning for malicious use of a telephone. Let's talk about that one.
I have no idea. I documented everything I did yesterday on Facebook, everything. And I talked to people and I've got everything documented. I was calling places, called VA. I was trying to get a hold of just different areas that can help me out to keep me safe. Talking to attorneys, talking to my neighbors, and my neighbors are coming up. My neighbors know what's going on. This has happened 3 or 4 times. That case I had a few years ago was dismissed by Stutzman.
Yeah, one was dismissed. One, no, he gave you 497 days in jail. Lay out. This complaint alleges that you used a phone to terrorize, frighten, intimidate, threaten, harass, molest, or annoy the peace and quiet of the Cynthia J. Thomason and the members of the Church of God by threatening physical harm or damage to the property. And that happened this morning, September 18th. They allege that you called the church and threatened to blow it up or something.
They
left some
said
messages on their phone.
That's why you don't believe anything on the internet or TV.
All right, so on that one, I'm going to show a plea of not guilty. Appoint an attorney.
Public building. I'm in a public building and facing a federal court, a judge.
Well, I'm not a federal judge. I'm just a.
Well, you are. There is no federal court. There is no federal court. You know that.
Well, I'm a district court, and you know me for all your life.
Yeah,
But
you know,
let
Matt,
me.
Could you get a hold of Matt or Liz or Tim Verhey or somebody for me?
Well, we're going to appoint an attorney and set an attorney pretrial for 10/3/25 at 8:30. Since you got out of jail in December, have you been hooked up with any mental health treatment?
Yes, every day with the VA. I was supposed to get meds sent today to the VA. That's what I've been waiting on for a while. And I've been calling them every day and checking in with my mental health and talking to triage nurses and talking to
Have you been taking your meds?
Yes. I'm doing everything they require me to do.
Well, I set this case as quickly as I could, which is next Tuesday, 9/23. Judge Patterson set the bond at $10,000, and I'm going to leave it as it was, same conditions as before.
What's that mean? Can't you just get a PR bond? I got lawyers and stuff.
Yeah, Jim, I'm afraid you're going to hurt yourself or somebody else, or somebody's going to shoot you. And you get off on these rants and you lose your temper. And
I'm not losing any temper. So this is not fair. This is not Robert's Rules of Order.
Center.
Robert's Rules of Order, United States Marine Corps, 386743923, James W. Roberts Jr., 100% disabled. Need
Yes.
VA assistance. You're supposed to send me to the VA or the Sturgis Hospital for 3 days for
Well,
mental
I
health.
think
I
we'll
want to
probably,
evaluate my mental condition. If I evaluate, I'd say you're incompetent and you stay in jail for a year and a half.
well, that wasn't up to me, but obviously we need to get this case on track.
This won't fly in court. This
So-
won't fly. This won't fly. Whatever. It ain't gonna fly. This is a public building, public place.
Yes, it is.
No, it's not.
All right. I
ain't
got
gonna
a
fly.
feeling you got another trip to the forensic center for evaluation in your future, but we'll determine
No, I
it.
don't. No, I don't.
Bond in the next case is 10,000 cash or surety. In the misdemeanor, malicious use of a telephone.
You don't know that. You're not the jury and the judge. That's false.
No, you're right.
No, he's the judge.
But I'm concerned about your safety, frankly.
Boy,
You and I've had
mental
this
health says
discussion
I'm
before.
okay. You're not a mental health doctor. My mental health people say I'm fine.
All right, well, we want to hear from them and confirm that. Your next court date is next Tuesday at 8:30. Judge Pattison set your bond at $10,000 cash or surety. I'll see you, or he'll see you at that time.
When I used to think about taxes, I would just
David Zambrano.
How you doing today?
Doing all right. It's a Tuesday. We got lots to do and we're making progress. Mr. Zambrano, we've had a hard time getting you in here. We got a lot going on here. In file 251521, you got a ticket on July 29th for driving without insurance and no valid license in possession. Those are both written under state statute. On July 25th, you got charged with driving with an unregistered vehicle in file 1523. On July 14th, you got charged with driving suspended and unregistered vehicle. That one's under White Pigeon ordinance. So July was a bad month for you. Then we said this a couple times. The city or the village of White Pigeon in the July 14th case has agreed to dismiss the charges if you plead to allowing another to violate the motor vehicle code. I'm not sure what the county's position would be on the other charges. And frankly, I don't know why they didn't charge him with driving suspended on all 3 days. Let's take a look. And then you missed a date and then they reset it and I don't know what happened, but
Your Honor.
yes.
I'm appearing here today, pro se, in the special appearance sui juris and in propria persona. I respectfully assert my rights to represent myself and have my constitutional rights recognized and upheld throughout these proceedings.
All right, well, that's certainly your right.
Thank you, sir.
You live in South Haven?
Actually, I'm a sojourner of the land. I don't have a residency at the
Well, the reason I ask, I
once did,
if
sir.
I need to send you mail, I need to know where to send it.
Right now, I do not have an address.
All right. Well, you do certainly have a right to represent yourself, and I don't have a quarrel with that. What do you want me to do? Set these for a trial? Or set a pretrial on all of these? Some are under White Pigeon ordinance, some are under state statute. You can help alleviate this by getting insurance, getting a license. It looks like you have some out-of-state problems. And you haven't had anything on your Michigan record in a long time. 12 years or more. So how would you like me to proceed here?
What are the charges? Again, all the ones that.
Well, right now, you're not doing a very good job of representing yourself because you don't even know what you're charged with. Let me tell you again. You're charged with no insurance. That's a misdemeanor, punishable by up to a year in jail, a fine of not less than $200 and not more than $500. That was on July 29th. On that same day, they charge you with no valid license in possession, even though your license is suspended. They didn't charge that. No operator's license in possession is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. On July 25th, take a look at that one. No, that's the 29th. It's the same as the others. You got no insurance, no ops on person, unregistered vehicle. That was on July 29th. And those are all under state statute. On July 14th, you got another ticket. Take a look at that one. 1560. In that one, they filed a formal complaint that alleges that you were driving suspended and you had an unregistered vehicle, and that is under White Pigeon ordinance. Driving suspended is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. That carries 2 points, and it requires that your license be suspended. And then they charge that you have an unregistered vehicle. You could help all of these if you got insurance, a registered vehicle, and worked on getting your license back. So one thing I could do is set all these cases for a pretrial on the same day with the White Pigeon Village attorney and the county attorney and see if they can come to some resolution of all the charges. Is that acceptable to you?
Actually, no, I have a few questions I need answered before we proceed. I don't understand the nature and the cause of this action against me. And I'm is this a civil or criminal? It's criminal.
All right. You were here with your mom and she's here with you. So it's good that you support each other. She asked me the same question, which points out to me that you're not qualified to represent yourself if you don't know the difference between a criminal matter and a civil matter. These are criminal matters. They could result in a jail sentence and a sanction on your driver's license.
Thank you, Your Honor. Should the record reflect this is a criminal action then?
Yes, it is.
Okay. I just got to look at my papers and stuff.
All right.
So my next question about it is Constitution grants this court two types of jurisdictions.
Yes. All right, we're not gonna get into this, what I call Jabberwocky. It has no legal effect. I don't know where you get it or where your mother got it, from a online source or somebody that told you this, or they're giving you bad information. These are criminal matters. They're not terribly consequential. Normally, you wouldn't go to jail for these, although they do carry a potential jail sentence. You don't necessarily subscribe to our system, but I certainly don't subscribe to whatever you got written on the paper there. I propose we set this for a pretrial, and you try to get a registration and insurance, and then come in and share it with the prosecutor and the city attorney, and see if we can resolve everything. If we can't, we can set it for a trial, including a jury trial, I suppose. It's two different incidents. So it would have to potentially be two different cases. What I propose is you trying to do some things to get situated and have a pretrial with the city attorney and the county prosecutor.
Your Honor, I'm going to have to object to that. I need, before we can proceed, I need to know, it's upon the authority of the Sixth Amendment, I need to know the nature and the cause of these charges. Now, could you tell me if it is a common law?
No, these are statutory offenses written under the authority of the people of the state of Michigan. One of these is under the insurance code, and one is under the motor vehicle code. The others are. And I don't really wish to engage in this discussion. We've got about 40 other people waiting for their case, and you want to talk to me about how many angels can fit on the head of a pin. You're charged with two separate traffic offenses on two separate occasions. You have a right to have an attorney. I'd be happy to appoint one for you, but you don't want one. You want to represent yourself, which is your right, but you don't have the right to waste my time. So if you either want me to set it for a pretrial, I can do that. That would be my preference. Then you can sit down with both prosecutors, ask these questions, and see if it can be resolved. If it can't, we can set it for a trial, either in front of a judge or a jury. So what would you rather do here today?
Well, upon the authority of the Sixth Amendment, I'm asking that the court discloses the jurisdiction that I ask.
I just did.
You said it's a statutory jurisdiction?
Yes, you're supremely unqualified to represent yourself in this matter because someone sold you a packet of information that has no relevance in the modern universe that we live in. So I'm going to set this for a pretrial.
Your Honor, that would be practicing law from the bench if you proceed without me.
I'm a lawyer. I'm a judge. I practice law from the bench. I do it every day, all day. And
I'd like to, I do have a few more questions about this.
I don't have any more time to answer your questions. I have a question for you. What do you want me to do with it? Set it for a pretrial or set it for a trial?
Under a statutory jurisdiction, I've never heard of, I need to know where I can find the published rules of the criminal procedure under that.
Well, you can certainly find them on the internet. They're in the public library. You just put the number of the citation, 257904 under the Michigan compiled laws. All right. Mr. Stickley is the chief public defender. He's had an opportunity to talk with you. Mr. Stickley, what's your recommendation here?
My recommendation would be to set it for a pretrial. I'm happy to spend a few moments with this gentleman and show him where the statute is and maybe where he can Google or library.
And he's entitled to have copies of each of the tickets and the complaints, and so he can see it. So If you'd like, we'll get copies of their tickets for you. You got the ticket, but there's a formal complaint. I'm gonna set it with joint with the city and county for 2 weeks. October 7. Mr. Stickley is the chief public defender, and he's not exactly representing you, but he's here to make sure that your rights are protected. And he also can give you some advice and maybe point you in the direction of what you want to do. Again, it would be helpful if you would come in with insurance and a proper plate and perhaps an effort to get your license back. You don't want to stay on the driving suspended merry-go-round because it's very hard to get off of it. Once you get suspended, you live near White Pigeon. The other problem is I don't have an address for you, so I need a mailing address. When you go out to the, we can use your mom's address, but I'm going to need you to give the clerks some sort of address where we can send things to you.
Could you deliver it general delivery to the post office?
Well, you can give them that.
Okay.
All right. I'm going to want you to take him out, get him a proper notice for that pretrial on the 7th. Mr. Stickley will meet with you and get some of that information that you're looking for. All right, sir. I'll see you on the 7th.
That's going to be it for today, ladies and gentlemen. Tomorrow is Judge Gother. I think we're going to get rid of Judge Gother because it seems like all the material for him, I'm gathering this content, but it's disappearing. There's going to be a few judges that are going to be coming off the list. But you know what? It's okay. I'm here and I'm bringing this stuff to you. So that's going to be it for today, ladies and gentlemen. Ta-ta and ciao ciao. I'll see you on the next one and have a good evening.
Breakdown, you're the one I call. From the mountains high, come down to it all. With your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. Daniel, you make it better. From the wires tangled up to the broken dreams, you know how to man all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel. Fix it, Daniel. Fix it, Daniel. Make it right. When the world shuts down, and I can't see clear, you're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, fix it, yo, I'm standing tall to all you everything's okay.